Hello students, continuing our discussion on the series on private international law, we now discuss the topic of international commercial contracts. Trade has been a symbiotic activity for human beings in every recorded civilization. In the early stages of transnational commercial activity, a body of rules that regulated most of the aspects of the international trade and commerce existed. Problems within the trading activity being a common occurrence, there is a continuous need for an updated system of rules. Identification of the governing law of the contracts is a primordial concern in cross-border commercial contracts. It is difficult to identify which of the multiple and diverse connecting factors apply. It could be the place where the contract was made, the place of performance, the place of business of the parties, the place of payment, the payment currency, domicile nationality of the parties, and so on. The nature of the contract, sale, carriage of goods by sea or insurance, etc., and the nature of the dispute would help identify the law governing validity, illegality, non-performance or capacity, etc. The private international law in most countries addresses the fundamental question whether the same law should govern the formation, either the whole contract or parts of it, as well as the effect of the contract. Further, there is an increasing support and acceptance of the theory of proper law of the contract. In 1939, the Institute of International Law at Rome prepared a draft relating to contracts for sale and purchase of movable property. The 1956, 1960 and 1964 Hague Conferences considered the question of applicable law to international contracts of sale of tangible movables, and a convention relating to international sale and purchase of goods was adopted. The theory of proper law of contract is the preferred theoretical explanation of the subject. The proper law of contract. Most countries subscribe to the principle of autonomy of parties, though there is a divergence on the question whether the parties' freedom to choose the law applicable to the contract is absolute or limited. Proper law of a contract refers to the legal system that the contracting parties intended to govern their contract. Such intention must be expressed bona fide and it should not be opposed to public policy. Absence of such express or inferred intention, the courts endeavor to impute an intention by identifying the legal system with which the transaction has its closest and most real connection. Where the parties fail to specify the governing law, the place where the contract was made, its form and object, the place of performance, the place of residence or business of the parties, jurisdiction, and such other links are examined by the courts to determine the system of law with which the transaction has its closest and most real connection. Modern proper law of contract theory has two strands: A. Express implied choice of the governing law, and B. Absence of such choice, the law that is closest connected with the contract. Express choice. Parties could also pick and choose the provisions of the law of their choice. They can decide to apply the entire law or a few parts of it, or some provisions of the chosen law. They could also vary that choice. It is also possible that a contract may be partly governed by one proper law and partly by another. Incorporation of certain provisions of a foreign country in the contract is different from the choice of that law as proper law. For example, parties have specified that English law is the proper law of the contract and stipulated a provision of a French law to govern a specific part of the contract. Such stipulation of the provisions of the French law does not make French law the proper law of the contract, but where the foreign law is the proper law of the contract, changes in such foreign law have a cascading effect on the contract. Can parties choose any law as proper law? Yes. As such, unfettered discretion would ensure certainty apart from the adherence to the principle of party autonomy. Lord Atkin in R versus International Trustee case observed that the intention of the parties is to be ascertained from the intention expressed in the contract. Implied choice. If the contracting parties did not expressly state the governing law, the intention could be inferred from the terms and nature of the contract and its performance. The proper law of the contract is founded upon such inferred determination. In Ascension case, an English standard form contract written in English was formally concluded in Paris, but freight and demurrage were payable in Italian lire. The courts stated unanimously that Italian law was the proper law of the contract because most of the contract was to be performed in Italy. Guidance on inferring an implied choice of law can be found in Egon Oldendorf versus Liberia Corporation case. A contract between a Japanese company and a German company did not have an express choice of law clause. There was an arbitration clause with arbitration seated in London and in the standard charter party contract. The parties had not expressly agreed whether English or Japanese law applied. The plaintiff had demonstrated with reasonable certainty that the parties had intended English law to apply. London seated arbitration for disputes arising out of the charter party contract that contained well explained standard clauses. Implied choice of English law was inferred. In Amin Rashid Shipping Corporation versus Kuwait Insurance Company, the House of Lords inferred from the terms of the contract that English law was the applicable law. The plaintiffs, a Liberian company carrying on a business in Dubai, insured a vessel with the defendants, a Kuwaiti insurance company. The insurance policy was a standard Lloyd's policy as set out in the Marine Insurance Act of 1906. The House of Lords held that the parties intended their contract to be governed by English law. This inference was founded on the ground that it was not possible to interpret the policy without recourse to the British Act and to the judicial interpretation of that Act. Absence of express implied choice, real and substantial connection. Article 4 of the Rome Convention explains that when the proper law of the contract has not been chosen, the contract shall be governed by the law of the country with which it is most closely connected. This is an objective test under which the applicable law is ascertained by looking at the connecting factors. Depackage is also possible. A severable part of the contract which has a closer connection with another country may, by way of exception, be governed by the law of that country. The presumption is that the contract is most closely connected with the country where the party responsible for its characteristic performance has his habitual residence at the time of conclusion of the contract. It must be emphasized that it is the country of the characteristic performer that matters when identifying the applicable law under this provision, rather than the place where the characteristic performance was affected. Characteristic performance has been explained as being usually the act for which the payment is due, such as the delivery of goods, the provision of service, the granting of the right to make use of an item of property, and which is usually the center of gravity and the socio-economic function of the contractual obligation. Thus, although Article 4 Clause 2 of the Rome Convention places emphasis on characteristic performance, the applicable law is the law of the country where the party who is to effect it has his habitual residence, or in the case of a corporate or an unincorporated body, its central administration as at the time of the conclusion of the contract. If the party was acting in the course of his trade or business, it is to be presumed that the contract is most closely connected with the country in which that party has his principal place of business. If, however, under the terms of the contract, the performance is to be effected in a place of business other than the principal one, then it is to be presumed that the country is that in which that other place of business is situated. So, if Brett is acting in the course of his trade or business and his principal place of business is in England, then it is to be presumed that English law is the applicable law. If, however, Brett has his principal place of business in England, but he supplied the goods from his secondary place of business in Germany, then German law is presumed to be the applicable law. Formation of contract. Formation of the contract refers to issues like offer and its revocation, acceptance of the offer and its communication, consideration, issues of consent and its validity, legality of the contract and its enforceability. It is largely accepted that all aspects of the contract ought to be governed by the proper law of the contract. What constitutes an offer and an acceptance is a question of law. But whether there is a offer and an acceptance is a question of fact. Difficulties arise in the correspondence of offer and acceptance because different legal systems hold diverse opinion on the timing of the acceptance to make it complete and binding. For example, in common law countries, the acceptance is complete once posted, while in civil law countries, it is not complete till it is received by the person making the offer. The question then in transnational commercial contracts is the identification of the governing law. It's logical to accept that the contract must be valid by the law of the place where it has been created, lex loci contractus. However, practical difficulty of identifying the locus of the contract remained. For instance, in Albeko Schuhmaschinen versus Kamborian Schuhmaschinen Company Limited, the English court applied the proper law in order to decide whether an agreement was made. In this case, an offer was posted to Switzerland from England. An acceptance was alleged to have been posted in Switzerland, but was never received by the offerer. The question arose as to whether a contract came into existence. By English law, there would have been a contract. Immediately, the acceptance was posted. Swiss law, however, required receipt of the acceptance. Court applied Swiss law as that would have been the applicable law had the contract been formed, and held that there was no contract. The third important element of the contract is the presence of the consideration as an essential feature of the contract. While the common law countries perceive consideration as an essential feature, some countries' legal systems, like those of the French, German and Scottish, do not attach similar value to the presence of consideration in a contract. Material validity. Article 8 of the EC Convention on the Law Applicable to Contractual Obligations 1980 stated that material validity related to the validity of the terms of the contract. It suggested that the putative existing proper law ought to basis for a decision on material validity. In Re Bonacina case, the Court of Appeal held a contract unsupported by consideration as valid by applying the putative proper law, Italian law, though it was not valid by the English law. Illegality is governed by the applicable law rather than the law of the place of the contract or the place of the performance. Similarly, the English courts would not enforce a contract if it was illegal by its proper law. For instance, in Keller versus Midland Bank case, certain bonds were held by Midland Bank in London. The plaintiff was entitled to withdraw these bonds under the contract's proper law, that is, the check law. However, Midland Bank refused to release them on the ground that under the Czech currency control regulations, it was prohibited from doing so, despite the fact that the plaintiff had left Czechoslovakia and became a US citizen. The House of Lords held that Czech law was the proper law of the contract, and accordingly the bonds could not be released. Formal validity. Formal validity relates to the validity of the external manifestation of the contractual intention of the parties. For example, the contract must be made in duplicate, in writing, 2 signatures to a contract, a written non-competition clause in a contract of employment, and so forth. The concept of formal validity does not extend to third parties. For example, the requirement registration of the retention of title clause. If the contract is concluded between persons belonging to different countries, then according to Article 9 Clause 2, it is formally valid if it meets the formal requirements of either the governing law or the law of any of the countries in question. With regard to the traditional English rules, a contract would be formally valid if it complied with the requirements of either the proper law or the lex loci contractus. There are a few exceptions to this rule. No action could be brought on certain contracts unless evidenced in writing. In Leroux versus Brown, an oral agreement was made in France whereby the defendant, a resident in England, agreed to employ the plaintiff, resident in France, for a period longer than 1 year. This contract was valid and enforceable by French law, the proper law. However, by English domestic law, it would be unenforceable by virtue of section 4 of the Statute of Frauds, which required such a contract to be in writing. Despite the fact that the proper law of the contract was French, the English court classified the requirement of section 4 as a rule of procedure and held that the contract was unenforceable. Capacity. There is no uniform conflict rule to identify which law governs the legal capacity of the party to a contract. In common law countries, it is a question of contract and therefore governed by the proper law. The law of domicile, habitual residence of the party could also govern it. There are two conflict rules that could explain the law that governs the establishment and organization of legal entities. Firstly, law of the state where the legal entity is incorporated, registered. Secondly, law of the state where the legal entity has its central administration or main place of business, the real seat of business. How to choose either of these connecting factors? Firstly, the place of registration is used as the connecting factor, particularly in the common law countries, whereas conflict rules in many civil law systems, particularly those inspired by the German law, are traditionally based on the main place of business. Scope of the applicable law under the convention. A. Interpretation of the contract. Performance. The time and place of performance, alternative obligations, pecuniary obligations, due diligence. C. Consequences of the breach, including the assessment of damages, liability of the party responsible for the breach, claims for termination of the contract for breach. D. Extinguishing obligations and prescription and limitation of actions. Applicable law also governs the discharge of obligations based on force majeure. In Jacobs versus Credit Lyonnais, the defendants agreed to ship goods from Algeria on board ships provided by the plaintiff. The defendants contend that they failed to deliver a part of the goods because of military operations in Algeria, rendering the performance of the contract impossible. The Court of Appeal held that the defendants liable for damages, since the proper law of contract, English law, did not recognize force majeure as a defense for non-performance. Limitations on the applicable law. Mandatory rules. Mandatory rules are rules which cannot be derogated from by contract. In the Hollandia case, the plaintiffs shipped a machine on board a Dutch vessel belonging to the defendant carriers for carriage from Scotland to the Dutch West Indies. The bill of lading contained a choice of law clause in favor of Dutch law and an exclusive jurisdiction clause in favor of the Court of Amsterdam. While the machine was being unloaded, it was dropped and severely damaged. The damage was estimated at about £22,000 and the plaintiffs brought an action in rem against the Hollandia in the English court. The carriers, relying on both the jurisdiction and the choice of law clauses, applied for a stay of the English proceedings. Dutch law at the time still applied the Hague rules. Carrier's liability was about £250. English law applies the amended Hague-Wisby rules, whereby liability was about £11,000. Any agreement lessening the carrier's liability for loss or damage to the goods otherwise than as provided in the rules shall be null and void and of no effect. Regarding choice of law clause, the House of Lords held that the Hague-Wisby rules were of an overriding nature and that the English court would not give effect to a choice of law clause that would result in limiting the carrier's liability to a sum lower than that dictated by these rules. Accordingly, the choice of law clause was null and void. The Giuliano-Lagarde report gave examples like rules on competition and restrictive practices, consumer protection, employment protection legislation, and certain rules on carriage. Public policy. A provision of law chosen by the parties may be disregarded if it is manifestly incompatible with the public policy or the public of the forum. For instance, English courts would not enforce a contract which, though valid by its proper law, contravened the law of a friendly country. In Regazzoni versus K.C. Setia, a contract for the sale of jute bags from Indian defendants to Swiss purchasers provided for English law as the applicable law. The defendants knew that the purchasers intended to transport the jute to South Africa and both knew that such a transport was illegal by Indian law. The defendants failed to supply the goods and relied on the illegality by Indian law. The House of Lords held that although the contract was legal by its proper law, the English court, as a matter of public policy, would not enforce a contract where the parties have set up to break the law of a foreign and friendly state. Principles of public policy could equally be invoked where a contract, though valid by its proper law, involved the commission of an act which was unlawful by the lex loci solutionis, that is, the law of the place of performance. Contracts contrary to procedural law. Procedure of a contract is governed by the lex fori. If a contract's enforcement is against a rule of the procedural law, such contract would not be granted enforcement. Interpretation of a contract. Interpretation of the contractual terms is governed by the proper law. If the proper law ensured a clear meaning to the terms of the contract, such meaning alone must be applied to the terms of the contract. If such clear meaning could not be derived as the words were unintelligible or its meaning unclear under the proper law, but not under the law of another country, then it is reasonable to infer that the parties wished for the other law to apply to such terms. Such instances often occur in currency related determinations, an issue often encountered in arbitration agreements. Courts apply for lex monetae, the law of the country to which the currency belongs. Revalorization rights of the creditor, however, are to be determined by the proper law. Discharge of contract. Discharge of contract is governed by proper law. Performance of the contract is the first mode of discharge from contractual obligations. Further discharge from contractual obligations happens because of impossibility of the performance of the contract either in its original terms, because of the changed circumstances that render the performance impossible, by accord and satisfaction, and by novation, by any changes in the legislation in that country. Novation of a contract is substitution of one debtor for another. It is different from the replacement of one creditor for another. Money contracts. In a contract involving money obligations, the amount being fixed by the contract, the discharge is only through performance, and any change in the lex loci solutionis or the country of payment cannot affect the obligation. But where the currency has not been identified, such identification can be made from an inference of the intention of the parties as demonstrated by the terms of the contract. There have also been instances where arbitral tribunals have decided and awarded interest to offset the loss of currency value during the arbitral process within the contracts. To conclude, we have now understood the basic principles governing the validity of the contracts in the cross-border commercial law. We have discussed the law with regard to the fulfillment of the contractual obligations and the issues in identifying the governing law of the contracts. We have also addressed to the basic issues in the contracts that contain currency and debt obligations.